My name's Naomi Korn. I'm an IP consultant and I've been working for Jisc for many years in creating IPR toolkits, advice and practical tools. I work predominantly across the UK's public sector, so with museums, libraries, archives, funding bodies, universities and colleges. And my main areas of expertise are both looking at the opportunities that IPR presents, but also looking at how risks can be managed as well. Public organisations such as museums, libraries, universities and colleges will find themselves in a dual position. They'll be both generators of their own materials, which will be protected by IP, which they will invariably own the IP to. But also they will be users of third-party content in which third parties will have a claim over that IP. Now, because IP presents both opportunities for organisations in the public sector to maximise their assets, but also if they don't deal with it properly, it can also present risks. They need to consider it seriously. I would say that IP is actually the bedrock of all the activities that take place across an organisation. If they want to use material generated by third parties, they need to consider IP, but also at the same time, if they want to maximise access to IP that they own or that they have permission to use, they also need to make sure that they take it seriously and develop suitable strategies to support what they want to do in the long term, policies to make sure there's an appropriate governance framework to support the strategy, and processes to enable what they want to do to happen on an operational level. Libraries need to ensure that at the point of creation of new resources and also possibly at the point of acquisition of new materials into their collection, they have the right rights framework, the right permissions to ensure that they can exploit those materials either for commercial benefit or indeed to provide long-term access to them. It's simple. If they don't have the right permissions, if they haven't acquired copyright, then they're not going to be in a position to be able to maximise access to those resources, either with business models or other forms of methods that might enable long-term sustainability. Projects must think about intellectual property rights as early as possible. It's going to take time and it's going to take resources in order to identify, trace rights holders, negotiate the necessary permissions, and also develop a suitable risk management framework if they haven't been able to trace the rights holders that they need. If they go through a project and they haven't sorted out the intellectual property rights early, they may find themselves in a position halfway or 3/4 of the way through the project, or even at the end of the project, where they haven't got the necessary permissions that they need in order to make this material accessible and also to support long-term frameworks of sustainability. Initial decisions about intellectual property rights will absolutely affect future outcomes. So some examples would be if an organisation decides to release its material under a certain type of licence, such as a Creative Commons licence, even though if they change their minds, they can take that material down, anybody who's been given permissions under that license to use the content that they've licensed under a certain way, under the terms of that CC license, will still be able to use it in that way. So they cannot backwards affect people who've already used their materials. Organisations in the public sector absolutely need to take a strategic approach to intellectual property rights. They need to understand that a holistic approach to how assets are created, how they're negotiated, how they're used. They need to understand the role of the value proposition within that broader holistic framework will then help them determine how they should go about negotiating permissions from third parties, the types of permissions that they need as well. So, for example, if an organisation takes something that we call a one-touch approach to intellectual property rights, so this is a way of them negotiating once with rights holders for all the uses that they need for the use of a particular asset, as early as possible, they will then find themselves in the long term in a position where many different departments can use the same asset in many different ways. It can then also simultaneously develop suitable long-term sustainability models to support those activities and indeed to support the organisation as well if it wants. Organisations, I think, can benefit from visualising different concepts that underpin IP and licensing. For example, if they think about the resources that they want to be made accessible, possibly reusable and possibly charged to users as a ball of content, they recognise that probably this ball of content is going to be made accessible to the users via some kind of web-based interface such as the internet. And they will be using a license to provide access to this materials to the users. That's probably the first steps that they will need to consider. Now, if they then go back to the content and appreciate that within this content it can be treated almost as a pie, that there will be elements of content within these resources where the organisation itself will own the rights. And we spoke earlier about an organisation being both a user of third-party rights but also a generator of its own intellectual property rights. And I'll indicate that simply with a C in a circle. There'll be also elements of this pie where third parties may have generated content that the organisation itself then wishes to make available to users. And these third parties might be volunteers, students, freelancers and other contractors. Okay, and they will have a relationship to this content because they will own the rights that will enable this content to be used. There'll be other elements of the resources they wish to make available to users that will potentially comprise of works that are in copyright but where the rights holders are either unknown or cannot be traced. And there might just be other content as well that perhaps they don't know if it's in copyright or not. So essentially, the concepts here are that if end users wish to use this material, and if there are third-party rights in this material, an organisation will need to ensure that there is compatibility between what we term as the rights in, i.e. rights that the organisation does not own itself, that it needs to negotiate with any third parties, and the rights out that it is then subsequently granting to the end users. The rule of thumb is this: if an organisation wishes to make material available to end users, if it doesn't get enough permissions from any third-party rights holders, then it will effectively be providing resources that infringe copyright. There has to be compatibility of rights in and rights out. An organisation needs to get at least the same number of permissions, if not more, than the permissions that itself is giving to end users. And in fact, another key point is absolutely essential. Before embarking upon any project, an organisation needs to consider not only the rights that exist in this material it wishes to make available to its end users and try and negotiate the appropriate rights, but also it needs to identify the type of license, the type of permissions it wants to grant from end users. It's not going to be helpful for an organisation to embark upon a project where it seeks permissions from rights holders, then decides on its end-use licence and hasn't actually got enough permissions to fulfil the licence that it wishes to make the material available to its end users. Now, in terms of the relationship of intellectual property rights and licensing to making material available for free, licenses that can be used to satisfy this might be the Creative Commons suite of licenses. But because Creative Commons licenses are non-exclusive, there is no reason why, in fact, the same set of resources can't actually be made available under charge-for business models. And indeed, an organisation might also wish to start thinking about how that initial set of resources can be derived into another form and made available also to users as well. A good example might be that this ball of content represents, say, a low resolution image of works in its collections, But then maybe the high resolution image is made available under a different licensing regime. There would be nothing to stop an organisation to actually consider that. But what these two types of material have in common is that they will both include third-party rights. So in order to ensure that actually all this schema of licenses can be fulfilled, third-party rights holders need to be able to be contacted and to give their permission, give the right amount of permission to ensure that an organisation has the control, has the ability, has the flexibility to provide access to the materials in the way that it wants to provide access. I think organisations can deal with IP in a number of different ways. I think at the heart of maximising access to IP, whether it's free or whether it's charged for, staff need to have the awareness of the value of the IP that the organisation owns, but also the importance of ensuring that third-party rights are secured. And I think awareness can be nurtured through training. I think it can be nurtured through making sure that there is appropriate information within an organisation that relates to how IP can be protected, how it can be controlled, how access can be given to third-party content as well, and also rights that an organisation owns itself. And this might be done through developing an appropriate governance framework towards IP by ensuring that senior managers and also staff who are working on the coalface understand the value of IP, understand that rights need to be dealt with early on, understand the benefits of a one-touch approach to securing permissions from third parties, understand that use of third-party rights is supported by risk management, that how an organisation's appetite for risk can also determine how it makes content available, to whom it makes content available, and under what conditions. An organisation can also develop partnerships with third parties. It can develop partnerships with commercial companies who themselves might exploit that IP if the organisation doesn't have the appropriate framework in place to do so. There are some excellent free to use resources that people can use across the public sector to help them understand the IP issues that might underpin their sustainability models. The first that I'd recommend is the SCA IPR and Licensing Toolkit. The second is the SCA IPR e-learning module, which is divided into 6 learning objects, all free to use, free to repurpose, free to download. And they include Introduction to IPR, using and accessing third-party content, protecting and managing rights, Creative Commons licenses, the Digital Economy Act, and orphan works and risk management. The third resource that I would strongly recommend is the Risk Management Calculator. This is a wonderful resource that projects can use for assessing the indicative levels of risk associated particularly with making orphan works. So these are works where the rights holders are either unknown or cannot be traced, available to third parties under different types of licenses. And the fourth set of resources that I think projects may wish to look at are those that are created by the OER IPR support project. And again, there are lots of template tools in there, template rights clearance letters, there is a Creative Commons compatibility wizard, there are risk assessment tables, and I think those sets of resources will help organisations deal with the IPR and licensing issues that might arise.